And for those joining us on Zoom, for some of you, good morning. We are meeting today for a pre-launch event on the UN General Assembly report on peace, security, sexual orientation, and gender identity. Before we start, I would like to say that this is a hybrid event and it is being recorded and streamed on Zoom. I would like to thank the co-sponsors for this event, which includes the Human Rights Program, the International Human Rights Clinic of Harvard Law School, and the UN High Commissioner for Human Rights, in addition to the studies of women, gender, and sexuality at the Faculty of Arts and Sciences at Harvard University. The structure of the presentation will start with 20 to 25 minutes of a presentation and move on to 20 to 25 minutes of Q&A and or a discussion session. And for those of you coming in on Zoom, you will be able to ask questions or put your comments in the comments or Q&A section of Zoom. Our presenter today is Victor Madrigal-Borloz, who is the Senior Visiting Researcher at the Human Rights Program, in addition to being the UN Independent Expert on Sexual Orientation and Gender Identity. Some of you will have already worked with Victor, and some of you will have engaged him in his official role in the UN mandate. So without further ado, let me introduce Victor.
Thank you very much. I'm very touched by the fact that the academic home of the mandate yet once again allows me to do a pre-launch of my report to the UN General Assembly. The pre-launch allows me to actually try out some of the key messaging around the report and do what we not always do, which is to actually hear out loud how it is that the things that we have worked on internally for so long actually sound like and resonate like with the audience. As I was saying, Harvard Law School is the academic home of the mandate of the independent expert. I'm privileged enough to be the Eleanor Roosevelt Senior Visiting Researcher here. And of course, I need to thank the Human Rights Program and as well the International Human Rights Clinic, as well as other involved entities for their sponsorship of this event. The mandate of the independent expert on protection from violence and discrimination based on sexual orientation and gender identity was created in 2016 by the Human Rights Council of the United Nations. And it was created with the idea of providing visibility to the way in which violence and discrimination occurs in the everyday lives of lesbian, gay, bisexual, trans, and gender diverse persons around the world. It was therefore created. I think I'm going to change the microphone. It was therefore created, it was therefore created with a very specific evidence-based approach. The idea is that it collects, analyzes, and produces analysis of violence and discrimination for the international community. The second part of the mandate, the second part of the duties in the mandate is to actually identify good and best practice to advise states in order to work on the eradication of said violence and discrimination. The creation of the mandate was the result of a furious and extremely controversial process within the United Nations, and it was so controversial that the difference between those who were supporting the creation of the mandate and those that opposed it was barely of 4 votes. And as recently as this year, when the mandate was renewed for the second time, a motion presented by those that do not support the mandate to withdraw the words sexual orientation and gender identity from it was actually voted 2020 at the Human Rights Council and was only defeated because in the rules of the UN, if there is a tie, the nice carry it. Otherwise, I would today be speaking to you as the independent expert on violence and discrimination, period, which would have been too much of a job, I think, for me to handle. Why the fuss? Why is it that this is so furiously controversial in the context of the international community? Well, there's a number of countries in which there are state-sponsored policies of negation of the very existence of LGBT persons or persons affected by violence and discrimination based on sexual orientation and gender identity. But also, I believe that the reason why the mandate is so controversial is because its creation represents the acknowledgement by the international community that without including sexual orientation and gender identity as factors creating, facilitating, and perpetuating exclusion and violence, the analysis is incomplete. That you need the recognition of that factor as a necessary factor in the analysis of violence and discrimination. And I think this is what is quite difficult to stomach by some stakeholders that actually would like to continue pretending on the idea that this is not a valid factor of protection under international human rights law. I will need to remind most of you that as of today, 68 countries continue to criminalize some forms of sexual orientation and gender identity, 10 of them penalizing it with the death penalty, and 5 of which actually implement it quite regularly. So, on the basis of those understandings, the mandate has formulated a research agenda that seeks to produce evidence, to gather and present evidence as to the way in which sexual orientation and gender identity are relevant to the international community in the different threads and global agendas. Now, global agendas that, as you may know, in the United Nations include the 3 pillars of human rights, peace and security, and development. And the reason for this particular report in the context of that global agenda is the understanding that certain forms of gender-based violence that very specifically affect lesbian, gay, bisexual, trans, and gender-diverse persons do so during armed conflict, and that these forms of violence exceed the scope and definition of conflict-related sexual violence. I have always worked in the understanding that gender-based frameworks and intersectional approaches provide a sharp lens to analyze violence and discrimination and the way that it occurs at the intersection or point of intersection of many identities, and that they provide a key to interpret and analyze multiple asymmetries of power that derive and are connected to the way in which sex is understood to exist within the context of society. So not only sex, but also the meaning attributed to sex, which has consequences through gender stereotyping, preconceptions, and the automatic assignment of norms according to what is understood to be proper and due to the male and the female. Furthermore, there was a second reason why I thought that this was fundamental. The first one being this notion of this differentiated way in which LGBT persons are affected in armed conflict, which led to my research question, which is whether there is evidence that sexual orientation and gender identity are weaponized in the context of armed conflict, and whether, in strategic and tactical terms, sexual orientation and gender identity are used as factors that inform the thinking of parties to a conflict in the way that they can perpetrate damage, so that this damage can actually influence the outcome of the hostilities. A third element derives from some existing evidence in modern atrocity analysis, where it is seen that persecution on the basis of sexual orientation and gender identity usually is followed by more systematic and more generalized attacks on diversity, and is generally put at the service of the implementation of patriarchal, heteronormative values and legislation that indicate a constriction of the rights, freedom, and safety of a society. And on this, of course, I'm particularly interested in the way that this is placed in patterns of democratic erosion, including, of course, the rule of law and separation of powers, and other structures that are put under disproportionate tension when at armed conflict. Some preconceptions lie at the base of the report, which is essentially starting with a legal inquiry, and those are that international humanitarian law, international human rights law, international criminal law, international refugee law, and the women, peace, and security agenda within the United Nations are not mutually exclusive. That any attempt to signify or lead to the conclusion that these frameworks are mutually exclusive is mostly informed by an idea of excluding rights that are fundamental during peace and armed conflict alike. And that the contention that human rights exist only during peacetime is fundamentally flawed. This is part of a legal process of inquiry in which I examined the uniform conclusion of a whole series of global and regional interpretations in which is understood that there is a core of human rights obligations that continue unaltered during armed conflict, as does certain criteria for the suspension of the remaining rights. And therefore, this creates a very harmonious environment for the coexistence of all of these legal regimes. This is relevant in practice for the work within the United Nations, because there's an understanding somehow in traditional approaches to the work of the UN that human rights are done in Geneva and peace and security and development are done in New York. And that when one, as an independent expert, visits New York to present certain aspects, one is actually intruding in the work of the United Nations in a way that is not relevant or that is not proper. And this report, in its wider understanding, is also aiming at debunking that understanding. Human rights-based approaches are relevant for the whole scope of work of the UN, and are, of course, also applicable and necessary in the context of armed conflict. I should also say that while the idea of creating this report preceded by a lot the Russian invasion of Ukraine, the very specific issues that are examined therein, in this report, actually became very obvious to me when looking at the dynamics of the armed conflict created by the Russian invasion. And therefore, I think that you will see some issues that might resonate in relation to the way that this has actually played out in that very lamentable process. I'd like to have a word, to just say a word in how the methodology of the report was crafted. Because the mandate has its academic home at Harvard Law, I benefited from a background note. Sam Bookman, who is here, led a lot of work in relation to that, and Daniela Diaz-Villamil, who was an LLM student last year, had a fundamental role. I also benefited from case studies which were prepared by the International Human Rights Clinic under the supervision of Professor Anna Crow, and prepared by Catalina Ustamarrugo, Anna Bauer, and Marilyn Medeiros Pereira, were fundamental building blocks that actually informed the report. And then I had the benefit of 27 ample inputs that I received as a result of my call for inputs coming from states and NGOs from all regions of the world, and creating a very robust evidence base. That led to a report that is being previewed today, but will be presented for the first time to the community of states at the third committee of the United Nations General Assembly in New York on October 28th, and will be the object of an interactive dialogue with states in relation to the issues. And then there's going to be a dissemination campaign that will take hold for the next 3 months, hopefully leading to the purpose that the report be used by states and civil society in crafting new approaches so that we can address this scourge of violence and discrimination based on sexual orientation and gender identity. The definitional framework created by this report, or identified by this report, actually aimed at focusing and producing evidence in relation to violence that manifests itself, as I said, against LGBTIQ+, or otherwise any persons affected by violence and discrimination based on sexual orientation and gender identity. And it presents a number of cases in which there are patterns of violence, some of which build strategically on existing structural drivers of discrimination, such as criminalization that I have mentioned, or pathologization of sexual orientation and gender identity, and actually exacerbate the functioning of those patterns within a particular context in a situation of armed conflict. And the common feature of this instrumentalization of sexual orientation and gender identity is that it actually seeks to consolidate population control by imposing or reaffirming moral, social, economic, and military orders that are considered quote and unquote correct under an understanding of gender, or to maintain legitimacy before a population that would actually be qualifying diversity as undesirable. The weaponization of prejudice was noted first by the eminent international and regional experts on Yemen, was also present in the conclusions of the Truth and Reconciliation Commission of Peru, and is most evident in the Colombia Truth and Reconciliation process. And it crafted a concept that is not yet quite developed in international human rights law, but I think is going to become very relevant in the analysis of atrocity, which is this concept of violence by prejudice, and that has four basic elements. The first one being a strong relationship of social context with the types of violence, the symbolic impacts of violence beyond individual harm to the people directly affected, and the reinforcement within that concept of gender stereotypes and preconceptions, and the instilling of fear in people who identify with the characteristics of the victim. Thirdly, the existence of a series of objective indicators that actually facilitates the identification of persons under that category, and the hierarchical and exclusionary purposes of the violence itself. Because, as stated by the Truth and Reconciliation Commission in Colombia, this created gains in war, and I am citing, by violating people whom society considered undesirable, they, the actors in the conflict that were perpetrating, obtained social legitimacy. If society had rejected or denounced these facts, the perpetrators would have seen no advantage in their execution. This is also reflected in the tactical. It leads to the creation of what is now qualified in the report as catalogs of violence, which basically constitute a series of methodologies to create damage and harm on LGBT persons in a differentiated way that actually include, for example, the exacerbation of corrective practices, or in very many cases, rape heinously called corrective, perpetrated mostly against lesbian women. We can also think about coerced motherhood of lesbian women and bisexual women that are raped during armed conflict, and that is very much related to the accusation of the fact that lesbian and bisexual women are somehow enemies of the national state because they are perceived as not wanting to bear children, and they are perceived, which of course we know it's not the case, at not wanting to become mothers by definition. So all of these aspects are instrumentalized, but are however not present in the evidence base available internationally. All of these can be qualified as gender-specific risks, and of course will materialize in very many cases within gender-specific damage that is inflicted upon the persons that suffer it. Therefore, it then follows, once that this risk and damage is identified, what is actually the specific agenda that can be drawn from the evidence base available in the report. And the first one is, from the analysis of the 5 different frameworks that I mentioned, including, of course, the peace and security agenda, which is not in itself only a legal, but rather a political framework, there is a need to ensure moving towards inclusive and expansive definitional frameworks that are going to abandon the notion that gender is synonym with women only, and that recognizes not only the idea that we all live in gendered societies and therefore we are all influenced by gendered notions, including in the construction of toxic masculinities, but also that the binary male-female does not end up covering all of the enormous variety of human diversity, and that these frameworks need to include legally, which is why this is fundamentally important for my mandate, they need to include the possibility for protection of non-binary persons and other gender diverse persons. The other element comes from the conclusions of the case studies concerning the inclusion of the voices of LGBT and otherwise diverse populations, or SOGI diverse populations, in this report. And it relates to the idea that there is a significant possibility in the integration of the experience of LGBT persons during conflict in truth and reconciliation processes, but also in the peacebuilding and peacekeeping processes, not only those that are sponsored by the United Nations, but those that are basically at the root of what we know is sustainable peace. And this includes, on the basis of the great case studies that were prepared and that are flowing throughout this report, is the finding that up until now, sexual orientation and gender identity have been largely absent to those frameworks. In some cases, because of what appears to be a lack of integration in international human rights law frameworks, and leading to the fact that, as stated in the report, the majority of databases that we could find reflecting the functioning and the framework of some of the mechanisms created for truth and reconciliation and peace building and peacekeeping, there were very, very few that actually included this specific framework, which in some cases led to disastrous consequences. I have been very involved as independent expert into the great damage created by the differentiated approaches in Indonesia, particularly in the Aceh region, where trans women are subject to horrifying violence. And I traced that form of damage to the 2005 agreement that resolved a long-standing conflict, but that by not taking into account the risk of SOGI-based violence, created an environment that is conducive to that series of violations. The most recent example of a process that has taken into account and in a way created a new frontier in the inclusion of gender-based approaches in peace is the Colombian peace process, where a significant and very fundamental integration of gender-based approaches, including space for the LGBT communities to produce evidence, but also to be a part of the construction of solutions. And there are a significant number of elements in the agreements and in the follow-up that lead to specific work in relation to LGBT populations, communities, and peoples. As you know, this created a significant opportunity for attacking peace agreements in the subsequent referendum, which was called by Colombia, and that led to a decision of which did not take forward the agreements in their formulation. I was, however, delighted to be chairing an event 2 weeks ago where the Vice Minister for Foreign Affairs of Colombia, of the new government that has been installed, declared the intention and the commitment of the Colombian state to take forward the peace agreements in their current form, and that, of course, then including the particular conclusions and agenda for action that they represent in the agenda against violence and discrimination. By definition, this is just a very wide panoramic view of the report to be presented, and the report itself is a very wide and panoramic view of an evidence base that is actually quite rich. I don't know how many of you are familiar with the idiosyncrasy of the UN, and part of that idiosyncrasy includes that my reports can only have 10,700 words. So that means that oftentimes huge knowledge bases get to be distilled in very, very succinct way, to use a mostly neutral term, in 17 pages, when I would of course wish for more. But the good thing about a holistic understanding of that knowledge base is that all of the elements of the knowledge base are published in the website of the mandate, and hopefully they will constitute a stock that scholars and state agents and NGO activists and advocates can use in the future. My last sentence on this has to do with what we've seen happening in Ukraine. In Ukraine, I visited Ukraine as an independent expert the year before the Russian invasion. And I noted a state of affairs that was quite mixed. A very determined political intention to address violence and discrimination based on sexual orientation and gender identity, to work for the human rights of LGBT people, but a contextually very difficult environment that included pervasive views of LGBT persons that were mostly negative and that had led to significant violence, institutional, social, and specific against them. But I noted that that willingness had already penetrated and percolated into significant mechanisms in law and in public policy. And I was very optimistic when I left Ukraine, and not only when I left it, but also when every few months after that, I had conversation with the Ukrainian government and with the civil society, with the UN present in Ukraine, to actually examine the state of affairs. I issued a statement soon after the invasion by the Russian Federation to the effect that all of that has been destroyed. All of that framework is no longer in place. And this is added to the fact that the invasion has created significant and well-fundamented fears by the LGBT community, given that the experience already in Crimea was that patterns of persecution against LGBT persons had been part and parcel of the strategy of colonization of the Crimean Peninsula. And this is a very mixed and complex situation, because not only this reflects an intent already reflected in the so-called gay purge in Chechnya, for example, within the Russian Federation and outside in the Crimean Peninsula, but also the difficulties created by a very hostile environment in Ukraine itself, which was existing before the invasion. And the combination of those factors has led, for example, to the inexistence of legal recognition of gender identity in the country. And that meant that when trans women attempted to leave the country or have attempted to leave the country, they have not been permitted to do so, because legally they are registered and recognized as men. And therefore, if they are between the ages of 18 and 58, they will be required to stay in the country for possible service, even though their gender, as under international human rights law standards, is that of women. And secondly, it's led to the reality that in a recent conversation with one of the few and the largest LGBT organization in Ukraine, I received the information that all throughout the conflict, there has only been 16 dedicated beds in the whole of Ukraine for LGBT community, in a situation where lesbian and gay and bisexual trans persons are constantly denied access to shelters that are put in place for the protection of internally displaced peoples, which, as you know, are in the millions in Ukraine. And so if the general population of internally displaced persons is in the millions, we can only expect that the population of LGBT persons is in the tens or hundreds of thousands, if statistical predictions or estimations can actually serve that purpose. So the impact of what we are talking about, the impact of the inexistence or active denial of the duty to create these frameworks actually has impacts on very real people under desperate situations of very real violence in the context of armed conflict. And I'm hoping that this report will be a contribution to the work of recognizing the need to create those frameworks and lead to a better understanding of how they can be put in place for protection. Now I'm looking very much forward to the conversation, but I thank you very much for your time. Thank you.
Thank you, Victor. Can we start the other microphone? Yeah, either of those. Thank you, Victor. I can understand how difficult it is to boil such a large and extensive report to a 20-minute presentation. But let me hand the floor to participants, and I'll bring over the mic to anyone who has questions.
Thank you so much for such an interesting talk and your work and sort of pushing this academic endeavor and also in terms of like raising awareness of this issue. I'm curious as to how you conceive of this article, and this is a very generic question, sort of contributing to pushing the needle in protecting LGBT rights, gender rights on the international stage or maybe even in the domestic stage. It's pretty incredible that the UN would even approve of such a mandate at all, given the attitudes of certain countries. How do you conceive of the trajectory going forward after this report?
I'm trying not to have. What? Testing 1, 2, 3, 4, 5. Is that working? Yeah. Okay.
Thank you. Can I make the question now?
Please.
Thanks a lot for the presentation, and thank you for keeping the whole name of the mandate and its violence and discrimination on SOGI issues. My question is like moving forward in terms of amplifying the advocacy pointers of your report. Which would be your recommendations to legal practitioners, to governments, and also more in particular, do you believe that there is an avenue to start building up customary international law to incorporate sexual orientation and gender identity as this ground or factor for protection, and mainly in the context of armed conflict, mainly through IHL, military manuals, training, and start collecting that, and who would be the allies there? Like I'm thinking about the ICRC, for instance. Thank you.
Thank you, Victor, for all your work in this report. I guess my question is both specific to this report, but also to generally how you conduct your work, especially considering the amount of resistance and opposition to the mandate itself that there is. And I'm just wondering the way in which that awareness of the resistance that the mandate generates informs the way you constructed this report, but also thinking about moving forward, the ways in which, how to make this report or how to harness it to reach the countries and the states and the organizations and the populations that most harshly deny or negate the existence of violence and discrimination based on SOGI, how to move forward with that.
Victor, let me hand the mic back to you, and then we'll return to questions after.
I think that would be great. And I'm hoping that this works, even though I move my head. Does it work? Does it work? I'll just do the handheld. That's right. The risk is that I will break down in song. I cracked myself up. Now I don't know whether this works. Is it on? Yeah. Okay. So, well, thank you very much for those questions. And I think the first and the third are somehow the different angles of the same coin. So I'm going to try to answer them second. And I'll address first the more specific one, considering the idea of how this body of evidence can actually move forward some of the legal frameworks in place. I think you mentioned the needle in relation to this particular issue. So let's take a couple of elements into consideration when we see this issue forward. The first one is that the resistance to amplifying frameworks doesn't necessarily come only from those that are detractors of work to eradicate violence and discrimination. It also comes from sectors that have not seen yet the importance and the need to recognize the way in which sexual orientation and gender identity are, in a way that by definition is improper under international human rights law, utilized to gain, to have gains in conflict, right? And of course, it's improper under international human rights law because the principle of non-discrimination operates clearly within any circumstances. But yet, from a legal perspective and a purely legal perspective, there's still resistance to, for example, the acknowledgement of non-discrimination as a principle of jus cogens in international human rights law, right? We all know that the Inter-American Court has said, but it has said that non-discrimination is jus cogens, but it has said it to significant criticism from other sectors that are more, let's say, perhaps focused on the formal process of creation of international human rights law. And so I think that it's a conversation that is not only waged into quote-unquote a good camp and quote-unquote a bad camp, it's also waged amongst persons that very sincerely believe in certain type of frameworks for the creation of international human rights law and for the recognition of certain grounds of protection. And it's a conversation that in that context is vigorous, and it's actually rich and full of content about systems that we are all trying to protect. Because of course, there's also a risk in that if we acknowledge everything as a source of international human rights law and everything as a factor, the tool itself loses its power, right? And I understand that, and I think that this is the reason why my mandate has taken as point of departure always an inquiry on the basis of Article 38 of the Statute of the International Court of Justice and the different conventions on the law of treaties about the way in which international human rights law is created, and following processes of state practice and doctrine, and trying to understand whether certain factors have acquired the rank of recognition under international human rights law that require for me to speak of these grounds. I'm firmly convinced that after carrying out those inquiries for 6 years, I'm firmly convinced that sexual orientation and gender identity have achieved that level of recognition under international human rights law. And therefore, that's why I'm interested in that conversation in a very specific way, because I think the legal evidence to that respect is persuasive. And therefore, to your point, I think that once we can advance to that legal conclusion, it is possible to see it interacting with other frameworks such as international humanitarian law and international criminal law. It's mentioned in the report that a few years ago, a number of colleagues, I think it was 12 colleagues and I, made a contribution to the International Law Commission on the draft Crimes Against Humanity Convention. And the specific issue that we brought forth, the ILC, was on the amplification of the explicit grounds for persecution. And there was a series of factors that we included where we recommended that explicit formulation would be in conformity with international human rights law and completely harmonious with developments under international criminal law and international humanitarian law. And I think that this is the way where this legal concept should penetrate. I just restated that advice along with 8 other colleagues in our input to the Office of the Prosecutor of the International Criminal Court, who is in process of restatement of their policy on gender. And in that process, we restated that contribution. Whether this is received by institutions that are formulating and taking forward frameworks of international criminal law, international humanitarian law, I think, of course, this is their responsibility. And it's certainly the responsibility of agencies in charge of this matter at the United Nations. So this report intends to actually speak to the peace and security architecture, just like my previous report on health spoke to the development architecture. One interesting fact that may facilitate this notion is that I think you'd be surprised the extent to which military structures have now recognized the strategic and tactical gains of inclusive approaches. When I did my report on social inclusion, a group of 32 military agencies presented a joint submission where they spoke about the advantages of inclusive approaches, including trans and LGBT persons. So I think that there is also an interesting aspect, which is not my mandate or for me to have an institutional opinion on, which is also the advantages in operational and strategic terms of inclusive approaches, which I think it's an interesting element. And then I go to the more general questions, and the link between them is, to me, you mentioned that it's surprising that such a mandate is adopted and supported at the UN, and I do agree. But in reality, what is surprising is that sexual orientation and gender identity are still so controversial in the light of repeated evidence that is provided by my mandate and by many other mandates, and that follows evidence produced in 2011 and 2015 by the High Commissioner for Human Rights, and which clearly lays it out in front of states and others that sexual orientation and gender identity are factors in violence and discrimination. And one may disagree or have different points as to same-sex marriage or to whether being gay is desirable or not in a context of society. And I acknowledge those discussions as possible discussions, but you should not be able to argue that sexual orientation and gender identity are not at the base of violence. You should not be able to do that and not be laughed out of the room of the General Assembly of the UN. It should be that that basically is accompanied by a chorus of laughter because you're not a serious player in the international community if you argue so. And again, this doesn't mean that we need to agree on every aspect of what that means, but we cannot simply continue. It's almost as ludicrous as saying that gender-based violence doesn't exist or doesn't affect women and girls. So to me, the future of the mandate and the framing of the mandate is continuing to provide that evidence so that it becomes at some point I'm going to say bad manners, given that I already think that it's contrary to international human rights law, that it's bad form to even try and argue this in an international forum. And what these reports are, and what the research that is taking point of departure in the work of the mandate here in its institutional home, they are building blocks for the states and for human rights advocates to actually use in their persuasion that this matter needs to be taken forward according to what is appropriate in legislation and in public policy. And that's what I will continue to do in the year that I have left as a mandate holder until October of next year.
Thank you, Victor. And with that, we officially bring this event to an end. Thank you for coming.